prosecution ready?
Yes, we're the prosecution, ma'am.
Thank you. And is defense ready to proceed?
Yes, Your Honor.
All right, wonderful. In the interest of efficiency, I'd like to go ahead and have the bailiff swear all the witnesses before we get started. So if the witnesses could stand and raise your right hand.
Do you solemnly swear or affirm that the testimony that you give today will be in accordance with the rules of the mock trial competition?
Okay, are there any preliminary matters?
Yes, Your Honor.
And then could you introduce yourself?
Yes, Your Honor. My name is Bella Coyne. This is Leah Grippo.
Good afternoon, Your Honor.
Good afternoon.
And Adley Ogles.
Good afternoon, Your Honor.
Good afternoon.
And first off, if Ms. Ogles may hand you a copy of our agreed stipulations. And at this time, we enter these into evidence.
You may approach. Any objections?
No objection, Your Honor.
Thank you.
So what is your preference on moving about the courtroom? Should we ask permission before approaching the bench and opposing counsel and the witness?
Please do ask permission before approaching the bench. You may approach the witness and you may approach opposing counsel to show exhibits.
Yes, Your Honor. Rule 16 of this jurisdiction prohibits witnesses from being sequestered, so therefore all witnesses will be present in the courtroom during the entire trial. Rule 17 requires that objection arguments be made in open court, so should we assume that all arguments are made outside the hearing of the jury, or should we ask for a sidebar first?
We can assume that all of those conversations are outside the presence of the jury.
And then if I could direct the court's attention to stipulation 15. Your Honor, the defendant is charged with 1 count of aggravated assault and 1 count of felon in possession of a handgun, but we are only proceeding on the count of aggravated assault at this time.
Thank you.
And with that, the state's ready to proceed.
Thank you. If the defense could introduce yourselves before you proceed with opening arguments.
Yes, Your Honor. Good evening. My name is Reed Smith. I'm joined here today by my co-counsel, Mr. Travis Swafford.
Good evening, Your Honor.
And Mr. Chandon Klimico.
Good evening, Your Honor.
And together, we represent the defendant, Mr. Leslie Lovinggood. Next, we notice that there's a podium in Your Honor's court. May we have permission to move freely during openings, closings, and examinations?
You may.
With that, Your Honor, the defense is ready for trial.
Thank you. All right, if there are no other preliminary matters, we will begin with opening arguments.
Yes, Your Honor. This case is going to take you to a small highway out in the country. It's just after 8. It's getting dark. It's quiet. There's a single mom exhausted from a long day's work, waiting to turn onto the highway. When she pulls forward, she cuts it a little too close to the oncoming car. They both slam on their brakes. She's embarrassed. She waves, and she drives away. But the driver of the other car, he's not having it. The driver speeds up, gets as close to the woman as he can, almost touching her tailpipe, revs the engine, and then backs away. Then he does it again, speeds up, gets as close to the woman as he can, revs the engine, and then backs away. Then he does it a third time. Now at first, the woman thinks that this is just some crazy punk kid. But then she notices that this driver is taking all the same turns that she is, even turning onto her street. The driver then speeds up again, but this time rolls down the window, sticks out a gun, fires a shot, and then another. One of those bullets came within inches of that woman's head. Now, thank goodness that woman got a good look at the other driver. Today, the evidence will leave no reasonable doubt that the other driver is sitting at the end of this table. On June 10th, 2021, when the defendant took the wheel, anger took control. Now, as the state, we can't just tell you that's what happened. We have to prove it to you. We're going to prove beyond a reasonable doubt that the defendant, Leslie Lovinggood, is guilty of aggravated assault. Now, in order to do this, we're going to have to prove three things. The defendant used a deadly weapon to make Miss Balding fear that she was about to be seriously hurt. So let's walk through how we're going to prove that today. First, Miss Balding is going to sit right here and walk you through everything that happened. There really won't be any debate today that Miss Balding was afraid for her life. She watched as a handgun was pointed right at her and fired twice. But you won't just have to take Miss Balding's word for it, because you're also going to hear from a state trooper who is a nationally trained ballistics reconstruction expert. When this expert examined the damage done to Miss Balding's side view mirror, she can tell you with near certainty that that damage pattern was most likely caused by a metallic bullet. And when the defendant was taken into custody just days after the shooting, a 9mm handgun was found on him with a partially loaded magazine. Now that brings us around to the third element. Was it the defendant? Today we'll be calling 3 witnesses to the stand, and each one of the 3 will prove the answer to that question is yes. You're going to hear that the thing that stood out the most to Miss Balding about the shooter was that the shooter was wearing a bright orange hat. You'll also hear that just a few hours before the shooting, the defendant was involved in an unrelated traffic stop. Want to guess what the defendant was wearing? A bright orange hat. And during this routine traffic stop, the defendant was screaming, cursing, fighting. The defendant was angry. And later that day, on June 10th, when the defendant took the wheel, that same anger took control. You'll also hear that after the defendant was arrested, he spent several months in jail. You're going to hear from the person who lived in the same cell as the defendant, the person who the defendant literally spent all his time with. And when that person asked the defendant why he was in jail, the defendant told him straight up, "Someone cut me off on the road, and I fired a couple of shots to scare them." The case you're going to hear today is a lot of things. It's shocking, it's sad, it's senseless. But one thing it's not is complicated. When the defendant got into his car on June 10th with a loaded handgun within reach, the defendant was all but waiting for the first thing to go wrong. The defendant was angry. And when the defendant took the wheel, anger took control. And when that anger took control, a woman was nearly killed. For that reason, we ask that you find the defendant guilty of aggravated assault. Thank you.
Yes, Your Honor. Now, everything Miss Ogles just told you sounds good. But here's the problem. The state has the wrong car, the wrong bullets, and the wrong explanation. See, when Billy Balding told the police what happened on the night of June 10th of 2021, she claimed to be certain about 2 things. The car behind her was blue, and she saw 2 bullets fly by her car with the naked eye. But the police soon learned that their only suspect drives a black car, not a blue car. They learned this suspect doesn't own the type of bullets that can be seen by the naked eye. And they learned this suspect has an alibi. Yet despite all this evidence that their only suspect, my client, Mr. Leslie Lovinggood, was not the shooter, they arrest him anyway. And if it sounds to you like the state of Tennessee has the wrong person, it's because they do. In fact, the proof will show today there may not have been a shooting at all. Because when the police went to arrest my client, they hadn't even investigated the very real possibility that Billy Balding was under the influence of a very powerful hallucinogen on June 10th. Members of the jury,
Good evening. My name is Reed Smith, and I'm proud to represent Mr. Leslie Lovinggood in today's trial. Mr. Lovinggood is 35 years old, and he walked into this courtroom today presumed innocent. Under the law, it's the state's burden to prove each and every element of their aggravated assault claim beyond a reasonable doubt. Members of the jury, that's the highest burden of proof in our criminal justice system. They must prove beyond a reasonable doubt not only that a shooting occurred on Sophia Lane, but that if a shooting did occur, my client was the shooter. We will highlight 3 simple facts today, each of which prevents the state from meeting this burden. Fact number 1, Leslie Lovinggood doesn't drive a blue car. Fact number 2, Leslie Lovinggood doesn't own the type of bullets that can be seen by the naked eye. And fact number 3, the state of Tennessee has the wrong explanation. But let's take those one at a time. First, the wrong car. Billy Balding claims to be certain that the car behind her was blue. But it will be undisputed today that my client doesn't drive a blue 4-door car. Fact number 2, the wrong bullets. Now, you're going to hear from a man today by the name of Ricky Rogers, an expert in the field of firearms and ammunition. Mr. Rogers will tell you there's only one kind of bullet that can be seen by the naked eye, a tracer bullet. But the evidence will show today my client doesn't own any tracer bullets. In fact, number 3, the state of Tennessee has the wrong explanation. You see, the state maintains that my client shot a gun at Billy Balding. But you're going to hear from a man today named Red Lovinggood, Leslie's grandfather. He'll tell you that he was on the phone with Leslie at the exact time Billy Balding claims the shooting occurred. And he didn't hear anything. It sounded like a gunshot. Now you're also going to hear from a man today by the name of Joe Trippett, a co-worker of Billy Balding, who will testify that he worked with Billy for 10 hours on June 10th, where Billy was exposed to very strong blue fumes that are known to cause hallucinations. Due to this complete lack of evidence, the state of Tennessee has resorted to a jailhouse snitch, who, the evidence will show, concocted a confession just so that he could get out of jail in time for Christmas. Members of the jury, all of this is why at the end of today's trial, my co-counsel, Mr. Klimico, is going to ask you to find my client not guilty. Because the state of Tennessee has the wrong car, the wrong bullets, and the wrong explanation. Thank you.
Is the state ready to proceed with its first witness?
Yes, Your Honor, the state calls Billy Balding to the stand. Please tell us your name.
My name is Billie Jean Balding.
Now, Ms. Balding, before we begin, I would like to take a minute to introduce you to this jury. Where do you live?
I live on Sophia Lane in Parton County, Tennessee.
How long have you lived in Parton County?
For about 25 years now.
Where do you work?
I work at a glue factory on the west side of town.
Do you have any kids?
Yes, I have 3 boys.
What grades are they in?
They're in 12th, 9th, and 5th.
Are you married?
No, I'm a single mother.
Ms. Balding, do you recognize the defendant seated at the end of that table?
Yes, I do.
How?
That's the man that shot a gun at me on June 10th of 2021.
How many times?
2 times.
Now, Ms. Balding, I would like to walk through that day with you. What day did you say it was?
It was Thursday, June 10th of 2021.
How did that day begin?
It was actually a pretty terrible day all around. I slept through my alarm in the morning, and I didn't have time to do my normal morning routine. All I had time to do was throw on some clothes and get in my car and head to the meeting.
Who was this meeting with?
My oldest son, Josiah, his summer school teacher.
Why did you have a meeting with the summer school teacher?
Josiah's junior year, his grades started to slip, so I had to enroll him in summer classes, and every couple of weeks or so, I would have a meeting with his summer school teacher just to check up and see how he was doing.
Now, Ms. Spalding, after this meeting, what did you do?
It was a shorter meeting, so I had time to stop and get some breakfast before I headed over to work.
What time did you clock in at work that day?
My shift started at 10, and that's when I clocked in.
Now, Ms. Spalding, I would like to take a minute to talk about your work at the glue factory. What does that involve?
So I work on the mixing line, so the raw materials will come in, and my job is to put them into a big metal vat and melt them down.
Is it safe to work on the mixing line?
It can be dangerous to somebody that's never worked there, but I've worked there for 5 years now, so I've really grown accustomed to how to be precautious around those fumes.
And is there anything that you can do to lessen the effects of the glue fumes?
Yes, if you have a good breakfast and you're not working on an empty stomach in general, that can help. And if you don't, the fumes can make you a little bit lightheaded or unsteady on your feet. And also the smell of the fumes can sometimes bother people. It actually bothered me when I first started working there.
Did you take a lunch break on June 10th?
Yes, I did.
Now, Ms. Spalding, I would like to talk a little bit about your day after work. What time did you clock out?
I clocked out a little bit after 8.
After you clocked out, what did you do?
I stayed behind and talked to one of my close friends from work, Sarah, before I got in my car and left.
Ms. Spalding, as you were pulling out of the parking lot, what happened?
As I was pulling out onto the parkway, I accidentally cut off a car, and we both had to slam on our brakes, and it was pretty embarrassing.
Was the car that you cut off in front of you or behind you?
It was behind me.
After this incident on Volunteer Parkway, what did you do?
I continued driving. I was pretty embarrassed by the whole situation altogether.
Ms. Spalding, what else happened on your way home?
A couple of minutes later, I looked in my rearview mirror and I noticed that there was a car really close on my bumper, and it would rev its engine and get really close to my bumper and then back off and then speed back up again and get really close to my bumper, and it did this over and over again.
Ms. Spalding, was it starting to get dark outside?
It was starting to get dark at the time.
Now, how close to your tailpipe was this car?
It was feet or inches. It was very close.
Now, Ms. Spalding, you mentioned that this car would get right up on your bumper. When this happened, were you able to see the driver?
Yes, I got a really good look at him.
Could you please describe that driver to the jury?
Yes, he had this really mean look in his eyes, and he was
Objection, Your Honor. Improper lay opinion. A proper lay opinion is one that is rationally based on the perceptions of a witness, and there is no foundation about what physical characteristics of these eyes would allow Ms. Spalding to opine that these eyes were mean. I ask that that foundation be laid if that opinion is given.
Your Honor, in her statement, she does say that the driver had mean eyes and was wearing an orange hat, and so that's where we got the basis for this line of questioning.
I'm going to overrule the objection, but let's move on quickly.
Yes, ma'am. Ms. Spalding, could you please describe the driver to the jury?
Yes, he had this mean look in his eyes, and he was wearing a bright orange hat.
Now, Ms. Spalding, this next question is very important. Is there any doubt in your mind at all that the driver was wearing a bright orange hat?
Not at all.
Did this car continue to follow you?
Yes, there are several.
Objection. Your Honor, this question assumes facts, not evidence. There's nothing on this record so far that about this car following her intentionally, as that would need to speculate to the mindset of this other driver. Ms. Spalding can certainly testify to what turns this other car took, but not to the mindset and if this car was intentionally following her.
Your Honor, I would ask that that line of questioning be saved for cross, as this car was driving right behind Ms. Spalding, and that's all we're trying to get out right now on direct.
Can you try to lay a little bit
Yes, Your Honor.
Thank you. I'll overrule the objection for now.
Miss Balding, as you turned onto your street, what happened?
As I turned onto my street, the car got really close to my bumper, and then he backed off of my bumper, and I thought he was gonna leave me alone, and then I heard a loud bang, and then another, and he tried to shoot me twice, and it was so terrifying.
Miss Balding, when these shots were fired, what did you see?
Well, when you're in a life-threatening situation, everything seems to slow down, and that's exactly what happened to me. I felt like I could see the bullets coming straight at me.
When those shots were fired, how did it make you feel?
I was terrified. I thought I was gonna die, and I thought my children weren't gonna have a mother.
Now, Miss Balding, after these shots were fired, what did you do?
I slammed on the gas, and I didn't stop until I got to my driveway.
When you got to your driveway, what did you do?
I called 911.
Did law enforcement ever arrive?
Yes, a lady from the state trooper's office came to my house, and she asked me some questions, and I told her everything that had happened.
Did you ever speak to that trooper again?
Yes, she came to my house the next day and showed me a picture and asked if it was the person that had shot at me, and I told her it definitely was.
Miss Balding, is that person in this room today?
Yes.
Could you please point him out by where he is sitting and an article of clothing?
He's sitting right there in the blue blazer with the green tie.
Your Honor, let the record reflect that Miss Balding has identified the defendant. No further questions.
You may proceed with cross-examination.
Ms. Balding, my name is Reed Smith, and I'm just going to ask you a few questions today. Is that okay?
Yes.
So on June 10th of 2021, you were headed home from work at the glue factory at which you work, right?
Yes, I was.
That day you were working a 10-hour shift. Got that right?
Yes, I was working a 10-hour shift that day.
And you're exposed to some glue fumes at the glue factory that are quite strong, right?
Yes, I would say they can be strong to somebody that's never worked there, but I've worked there for 5 years now, so I've really grown accustomed to how to be precautious around the fumes.
Man, these glue fumes are actually so strong, they've been known to cause hallucinations, right?
I would actually disagree. They can make you unsteady on your feet or lightheaded, but and like the smell can bother people sometimes, but I wouldn't say that they can make you hallucinate.
But you would agree that these fumes are so strong that they've actually caused people to fall into the melting vats before, right?
Yes, there was an incident a few years back, and so they employed a buddy system at our work just to ensure that nothing like that would happen again.
That's right, the person you were working with through the buddy system that day was a man named Joe Trippin. Got that right?
Yes, it was.
So Joe Trippin was in a position on June 10th to observe your behavior, right?
Yes, he was my buddy that day with the buddy system that we have at my work.
Now I'd like to talk about the car you claim to have seen on the night of June 10th. It was a four-door car. Got that right?
Yes, it was.
And now the color of this car is very important. And this car was a four-door blue car, right?
It was a really dark blue. I thought it was black at first.
The car was blue, right?
Yes, it was a very dark blue.
Are you aware whether or not my client drives a blue car now?
I'm not aware what kind of car he drives now.
And you certainly never identified the other car as a black Mustang, right?
No.
Okay. Now I'd like to talk about the bullets you claim to have seen on the night of June 10th. You claim to have seen 2 bullets fly by your car. That's correct?
Yes, I don't know how guns work, but I saw 2 bullets flying past me.
You saw them fly by with your naked eye, right?
Yes, again, I don't know how guns work. I'm no gun expert, but I saw 2 bullets flying past me.
All right, man. It was dark outside that night.
It was starting to get dark at the time.
So these bullets, they must have been bright enough if you had seen them with your naked eye
when it was getting dark, right?
Yes, the whole thing seemed to happen in slow motion. I felt like I could see them.
Are you aware that the state is alleging that a scratch on your car's side mirror was caused by one of these bullets hitting it?
Yes, I believe the trooper said something about that.
But you didn't see or feel one of these bullets hit the car side mirror, right?
I felt like the bullets were coming straight at me. I thought I had been shot at first because it was all a blur. It was so scary.
And I understand, redirecting you to my question, you didn't feel or see either one of these bullets hit your car side mirror, right?
I saw them coming straight at me, and I don't know what or if they hit anything.
I'm not asking you about that, ma'am. I'm asking you whether or not you felt or saw one of them hit the mirror on your car. Yes or no?
I saw them flying straight at me, but no, I didn't see whether they hit me or not.
And there's actually a simple explanation for why there's a mark on the side of your car's mirror, right?
I believe it was caused by the bullet.
Well, isn't it true that earlier that day you parked at your child's school in the parking lot?
Yes, I did.
And you parked so close to another car that you actually had to climb out the passenger's door.
Yes,
right?
there was only one parking spot left in the parking lot, and I was in a rush to get to this meeting because I hate being late to things, and I didn't want to scratch my driver's side window or the car, so I climbed out the other side.
That's right, you had to climb out the other side because you were scared. You opened your door, you were going to hit the other car, right?
Yes, and I didn't want to do that, so I just crawled out the other side.
And when you got back from this meeting, this other car, it was gone, right?
Yes, it was gone, so I was able to get back into my car normally.
Finally, ma'am, I'd like to talk with you about the person you claim to have seen that night. You spoke with both a 911 operator and a Tennessee State Trooper, correct?
Yes, I believe I did.
And you described the physical characteristics of the driver behind you, to both of them, right?
Yes, I did.
But I noticed the only physical characteristic that you described to them were this person's eyes. Is that right?
I noted the two things that I noted while I was driving was that the shooter, he had this mean look in his eyes and he was wearing a bright orange hat.
Ma'am, I'm not asking you about the hat or any other clothing this person was wearing, but just about their physical characteristics that you described. And the only physical characteristic you described were the eyes. Yes or no?
Yes, that was the only thing I put in my witness statement.
Well, why don't you tell the jury what color eyes did you tell the Tennessee State Trooper you saw?
I didn't put that in my witness statement, but I mean, I can't even tell your eye color from here, so I don't know.
I'm not asking what you put in your witness statement. I'm just asking you what color eyes you told the Tennessee State Trooper on June 10th.
I didn't note that he was, he had a hat on at the time.
Ma'am, redirecting you to my question, what color eyes did you tell the Tennessee State Trooper?
I did not include that in my witness statement, but I can answer if you'd like.
Yes, ma'am. Please answer.
He had brown eyes.
So you told the Tennessee State Trooper that night the driver behind you had brown eyes?
That's not what I told the Tennessee State Trooper.
So, ma'am, what color did you tell the Tennessee State Trooper?
I didn't put that in my witness statement.
Ma'am, I'm not asking you what you put in your witness statement. I'm just asking you what you told the Tennessee State Trooper that night.
Then I told the Tennessee State Trooper that I saw that he had brown eyes.
And you remember giving a sworn witness statement in today's case, correct?
Yes, I do.
Your Honor, I'm showing opposing counsel Ms. Spalding's sworn witness statement. Now I'm approaching the witness. Now, Ms. Spalding, in this witness, this is your witness statement, right?
Yes, I believe it is.
And you swore to tell the truth, the whole truth, and nothing but the truth.
Yes, I did.
But nowhere in here do you say that you told the Tennessee State Trooper on June 10th that this driver's eyes were brown. Do you?
Yes, I told you that this wasn't in my witness statement, but I said I could answer if you'd like.
And when you wrote this witness statement, you were told to include all facts relevant to today's case.
The two things that stood out to me the most at the time was that the driver had this mean look in his eyes and he was wearing an orange hat. But those were the things that stood out to me and that I put in my witness statement, but I didn't include that. No.
Ma'am, if you didn't include that in your witness statement, then, well, ma'am, how did you identify the driver in a photo line given to you by the Tennessee Highway?
I was shown a picture the next day of the driver, and I could never forget what he looked like.
Well, if you didn't use the eye color, There's actually a simpler explanation for why you identified my client, right?
I'm honestly not sure what you're implying.
Well, tell the jury how many photographs the Tennessee Highway Patrol showed you in this photo book.
He showed me one picture, and when he showed me that picture, I automatically knew that that was the person that had shot at me.
So, ma'am, just to be clear, the Tennessee Highway Patrol showed you one photograph, my client.
Yes,
Nobody else.
and when I saw that picture, I knew it was the person that had shot at me.
Thank you very much, Ms. Paulding. I have no further questions, Your Honor.
Is there any redirect?
No redirect, Your Honor.
Thank you. The state may call us next witness.
The state calls Trooper Tyler Thomas to the stand.
I'll just remind everyone that the witnesses have already been sworn, so we are not swearing each witness individually.
Your Honor, may I set up enlargements before I begin? Tell us your name.
My name is Trooper Kyler Thomas.
Trooper Thomas, what do you do for a living?
I work with the Tennessee Highway Patrol.
And what do you do with the Tennessee Highway Patrol?
I work with the Criminal Incident Response Team, or CIRT for short. I specialize in ballistics and crash reconstruction.
How long have you been working in ballistics and crash reconstruction?
I'm in my 7th year.
Now, you mentioned ballistics. What is that?
Ballistics is the study of flight characteristics and impact effects of launched projectiles, dealing usually with bullets and firearms.
And what is crash reconstruction?
In crash reconstruction, what we do is we collect and analyze evidence regarding vehicle collisions and crime scenes involving moving vehicles. We then apply our education and training to that evidence in order to determine what happened.
Tell us about that education and training.
I've trained in dozens of programs all over the country. I've studied forensic ballistics, advanced trajectory mechanics, advanced cartridge identification, and many others. I've also received advanced training in crash reconstruction every year since 2013.
Have you ever testified as an expert in ballistics and crash reconstruction in court before?
I have testified as both.
Your Honor, we tender Trooper Thomas as an expert in ballistics and crash reconstruction.
No objection.
Thank you. We proceed.
Trooper Thomas, I want to turn your attention to this case. How were you involved?
I was on duty the day of the shooting, and I was called to investigate a potential vehicular shooting near Volunteer Parkway in Parton County.
And after you received that call, what did you do?
I made contact with Miss Billy Balding at her residence at about 9 p.m. and then spent about an hour with her discussing what had happened.
What happened as a result?
I learned that Miss Balding had been shot at while driving her vehicle, and so I decided to have her vehicle impounded so I could examine it for any physical evidence.
Did you end up examining the vehicle?
Yes, the following morning.
Would you recognize did you take photos of the vehicle?
Yes, I did.
Would you recognize those photographs if I showed them to you?
Yes.
Showing opposing counsel has been previously marked as Exhibits H and I. Would you like a copy, Your Honor? I just handed you Exhibit H and I. What are we looking at here?
These are 2 photographs I took of Miss Balding's vehicle on June 11th, 2021.
And are they a fair and accurate depiction of that vehicle?
Yes, they are.
Your Honor, we offer Exhibits H and I into evidence.
Thank you.
May I use enlargements of those exhibits?
I'm sorry.
May I use enlargements of those exhibits?
Yes, you may.
And may Miss
Is there any objection?
No, Your Honor.
Thank you.
and may Trooper Thomas join me in the well?
I'm sorry.
And may Trooper Thomas join me in the well?
Yes, for the limited purpose of answering any questions about these enlargements.
Your Honor, I'm going to move over to that side so I can see them more.
Certainly. Go ahead.
Can you all see if I put it here? I'm showing the jury Exhibit H. What are we looking at here?
This is the driver's side of Miss Balding's vehicle.
And what type of vehicle is this?
It is a 2005 Nissan Maxima.
What, if any, area of Miss Balding's vehicle was important to your investigation?
Right here, at the edge of the side view mirror.
Why was that area important?
As you can see, there's a pronounced discoloration in a very concentrated area. I did a closer examination and took a closer photograph.
I'm now showing the jury Exhibit I. What are we looking at here?
As you can see, the pronounced discoloration is in a very concentrated and defined area. And, what is perhaps most important, is that the color is metallic, or brassy.
Did you reach a conclusion as to the cause of this damage pattern?
Yes, I did.
Did you have sufficient facts and data to reach that conclusion?
Yes, I did.
Was your conclusion the product of reliable principles and methods?
Yes.
Did you apply those principles and methods reliably in this case?
Yes.
And did you reach your conclusion to a reasonable degree of both professional and scientific certainty?
Yes, I did.
Trooper Thomas, what is your conclusion as to the cause of this damage?
This damage pattern was most likely caused by a metallic bullet.
Thank you. You may take your seat. After you examined Miss Balding's vehicle, what did you do next?
I returned to the scene of the crime, took some additional photographs, and interviewed some of Miss Balding's neighbors.
And what happened as a result?
A name that came up multiple times in those interviews was Leslie
Objection, Your
Lovinggood.
Honor, to hearsay.
Now, may I respond? We're not offering this for the truth of the matter, but rather effect on listener. This shows the connection for why the trooper began to investigate Leslie Lovinggood.
Your Honor, the name Leslie Lovinggood is certainly being used for the truth of the matter, sir. The fact that the neighbors identified Leslie Lovinggood as a potential suspect for Trooper Thomas to investigate goes to show that Leslie Lovinggood might have been someone dangerous or irrational or violent, which prejudices the jury.
Your Honor, I stand by, we're not offering for the truth of the matter. This connects for the jury why Trooper Thomas began looking into Leslie Lovinggood.
I'm going to allow the questioning and overrule the objection.
Why was Leslie Lovinggood's name significant?
It was significant because I had actually interacted with Leslie Lovinggood earlier in the afternoon on the same day as the shooting.
Tell us about that interaction.
I was called in for backup at a routine traffic stop with another trooper. Leslie Lovinggood had been pulled over and cited for a number of traffic
Objection,
offenses.
Your Honor. This is improper character evidence. Using the fact of the interaction that Leslie Lovinggood had been pulled over by police earlier in the day has no relevance on whether he later in the day fired shots in another car.
Your Honor, may I respond? This is not character evidence under 404B because we're using this to prove motive and state of mind of the defendant.
Your Honor, whether or not Mr. Lovinggood was speeding on the day of June 10th has no impact on the motive he had later in the day, several hours later, after he was released from jail.
Your Honor, may I respond? If I'm allowed to continue my line of questioning, you'll learn that at this traffic stop, the defendant was angry, which is allowed under 404B because it goes to prove motive and state of mind.
That's exactly what we're trying to exclude. The fact that Leslie Lovinggood might have been irrational at a traffic stop or that he became angry very easily is something that would go to the fact that he might be more willing or likely to fire a bullet. That's definitionally improper character evidence.
May I respond? We're not trying to prove that he's an angry person, which would be character evidence under 404A. Rather that he was angry in this motive, which is allowed under 404B as motive and state of mind.
I'm going to sustain the objection if you think this is being offered to prove conformity, action and conformity. So we're going to sustain the objection if you can move on questioning.
Excluding anything that happened at the traffic stop, what was Leslie Lovinggood wearing?
Mr. Lovinggood was wearing unremarkable clothing, other than a bright orange hat.
And what description did Billy Balding give of the person who shot at her later that same day?
She said that the shooter had mean eyes and that he was wearing an orange hat.
Did you interact with Billy Balding again?
Yes, I did.
What was the purpose of that interaction?
I took a photograph of a potential suspect to her for identification.
And how did Billy Balding react to that photograph?
She positively identified the photograph shown as the person who had shot at her on June 10th, 2021.
Trooper Thomas, who was that photograph of?
It was a photograph of Leslie Lovinggood.
Based off of all the evidence you gathered in your investigation, what did you do next?
I took out a warrant for Leslie Lovinggood and placed him under arrest on June 15th, 2021.
And did you collect any evidence off of him?
Yes, I conducted the standard pat-down and located a 9mm Sig Sauer P239 pistol on Leslie Lovinggood's person.
Would you recognize the photograph of that pistol if I showed it to you?
Yes, I believe I would.
Let the record play. Would you like a copy? I've just handed you Exhibit L. What are we looking at here?
This is a photograph of the gun that I found on Leslie Lovinggood's person.
And is it a fair and accurate depiction of that gun?
Yes, it is.
Your Honor, we offer Exhibit L into evidence. Trooper Thomas, what did you observe about that 9mm handgun?
It had an 8-round magazine with 5 rounds of ammunition in it.
Thank you. No further questions. Your Honor, may I publish Exhibit L to the jury?
No objection.
Sorry, I only
Before
have
we
the 2
begin
copies.
cross-examination, take the demonstrative out as well.
I've got you.
Oh, I can take care of it. Okay, thank you so much. May I proceed, Your Honor?
You may proceed.
Officer Thomas, I want to start with something that we just heard in trial. You heard Miss Balding testify that she told you the shooter's eyes were brown, right?
Yes, she did.
But the truth is, she didn't tell you, did she?
She did tell me that.
It's your testimony in court today that Miss Balding told you the shooter's eyes were brown?
Yes, she did.
You remember giving a sworn witness statement in this case?
Yes, sir, I do.
And that witness statement, you were told to include all relevant facts, correct?
Yes, sir, I was.
You're told to tell the truth, the whole truth, and nothing but the truth, right?
Yes.
Your Honor, I'm approaching the witness with her sworn statement. Now, I've read this witness statement 5 times over, Ms. Thomas. Not once do you mention that Miss Balding told you the shooter's eyes were brown, right?
I do not mention that in my witness statement.
And you were told to include all relevant facts, weren't you?
Yes, I was.
And you actually only included that Miss Balding told you the shooter's eyes were mean, right?
Yes.
But she didn't tell you the shape of the shooter's eyes, did she?
She did not.
She didn't tell you the size of the shooter's eyes?
She never testified to that today either.
Well, one thing she did tell you was that the car the person driving behind her was driving was blue, right?
I do not recall her telling me anything about the car. I think that was all included in the 911 phone call.
It's your testimony she didn't tell you anything about the car?
I'm not sure if I remember her telling me anything about the car.
You remember everything you said in the witness statement, don't you?
Yes, I do.
And you still have that witness statement in front of you?
I do, yes, sir.
Let's turn to the second page of that witness statement. The first sentence, in fact, says, Billy Balding stated that on the way home from work, a blue car was tailing her. I read that correctly?
I apologize, sir. That was my bad. I must have forgotten.
So Miss Balding did tell you that a blue car was tailing her.
Yes, she did.
But during your investigation, you determined that Leslie Lovinggood actually drives a black car, right?
Yes, sir, I believe I did.
Objection, Honor, hearsay. There's been no foundation laid to how she would know that from a reputable source.
Trooper Thomas just agreed that it was part of her investigation and part of her determination that she searched or came to the conclusion that Mr. Lovinggood's car was black, Your Honor. There's no hearsay, there's no statement, there's no doubt.
Your Honor, I ask that more foundation be laid to how she came to that conclusion.
You lay more foundation and then you may proceed.
Yes, Your Honor.
You investigated Mr. Lovegood, correct?
Yes, sir, I did.
You went to his home, correct?
Yes.
And you determined that his car was black, correct?
Earlier on June 10th, I also encountered Leslie Lovinggood, and he was driving a blue car.
Well, you impounded that blue car, didn't you?
I did impound that blue
So
car.
there's no way for that blue car to be the one that was tailing Miss Balding that day, right?
It was not. You simply said that Leslie Lovinggood drives a black car, and I was correcting you on that fact. Leslie Lovinggood has both a blue and a black car.
But you did determine that the car you thought he was driving that night was black, yes?
Yes, sir, it was.
But even though Billy Balding told you the car was blue, that's not what you wrote in your affidavit complaint, right?
Excuse me, sir? I'm so sorry.
You were so determined to charge my client that even though Billy Balding told you the car was blue, that's not what you wrote when you charged my client. Got that right?
I'm not sure I understand.
Officer Thomas, you drafted the affidavit complaint in this case.
Yes, sir, I did.
You'd recognize that affidavit complaint if you saw it in court today?
I would.
Your Honor, showing opposing counsel Exhibit B. That person's witness. You'll flip to the second page of Exhibit B there, Officer Thomas. And that paragraph in the middle, the long paragraph, let's look at the second sentence there. You say, Billy Balding stated that a dark-colored car was driving erratically, following too close and attempting to hit her. I had that right?
Sir, I never testified in this that Leslie Lovinggood was driving a black car.
I just want to be clear, though. You say that Billy Balding stated a dark-colored car was driving erratically, right?
Sir, as I believe Billy Balding has already testified in both her direct and her cross this morning, the car was dark blue.
Ma'am, I just am asking a simple question with a yes or no answer. In your affidavit complaint that you drafted, you said Billy Balding stated that a dark-colored car was driving erratically. That's what you stated. Those are your words.
Yes, sir, that is what I stated.
But Billy Balding never told you that a dark-colored car was driving erratically, did she?
She told me the dark blue car was driving erratically.
We just saw your witness statement, didn't we, Officer Thomas?
She said that it was a blue car, and it was a dark blue car. It was a dark blue car. Those are the same
Not
colors.
once in your witness statement do you ever say that Billy Balding told you a dark blue car was trailing her, right?
I don't see how the extra adjective would be that much of a problem.
But ma'am, I just want to be clear, you did not include that extra adjective in your witness statement,
No,
right?
sir, I did not.
Okay. Now I want to talk about the bullets that Miss Balding allegedly saw on the night of June 10th, 2021. Even though she claims there were two gunshots, you never recovered any bullets on Sophia Lane, right?
No, sir, I did not.
You also never recovered any shell casings, right?
I did not recover any shell casings. I knew it was a long shot when I went out to search for them in the first place. In shooting cases like this, shell casings are rarely recovered, as this was a case with two cars driving down a road at high speeds. So the shell casings could have
Officer
easily
Thompson,
gone flying.
interrupt you there, I'm sorry.
Yes, sir.
There are no shell casings you found, right?
I did not find any shell casings.
I want to talk about that scratch on the car that you allegedly claim was a bullet, right?
Yes, sir.
Now, you didn't perform any scientific testing to determine that it was caused by a bullet, right?
I did physical testing, which is photographing and measuring the bullet scrape, and that is what I did.
We have a scientific lab here in Tennessee, don't we? You didn't perform any scientific testing?
The only kind of forensic testing that would have been applicable to this particular marking would be gunshot residue testing, which is a notoriously unreliable method of testing, and I did not use it in my investigation because of that.
You also told this jury you thought the bullet was caused by something metallic, but the truth is you never tested the scrapings on that mirror to determine what color or what kind of metal it was, right?
I did not.
One last thing for you, Sheriff Thomas. Besides the eyes, the one other defining characteristic that Miss Balding stated was about the orange hat, right?
Yes, sir, it was.
Many would agree we're in Tennessee, aren't we?
Yes, we are.
That's the volunteer state.
Yes, it is.
The University of Tennessee's colors are orange, aren't they?
Yes, I believe they are.
So orange hats certainly wouldn't be uncommon in the state of Tennessee, would they?
At the unrelated traffic stop earlier that same day, I saw somebody matching Miss Balding's description wearing an orange hat.
Ma'am, that's a no. They wouldn't be uncommon in the state of Tennessee.
They are not uncommon in the state of Tennessee.
Thank you, Officer Thomas. No further questions, Your Honor.
Thank you. Attorney Rush.
Yes, Your Honor.
Proceed.
Ms. Thomas, how likely did you think it was that you were going to find shell casings?
It was a very long shot in the first place. Shell casings are rarely recovered, as I have already said, in shooting cases that are like these ones.
Thank you. No further questions, Your Honor.
There's no request.
You go to the step down.
Your Honor, if I may have a moment to get the microphone on, and we'll call it, please. Yep. The state calls Shifty Wise, Your Honor.
I will remind you that you've already been sworn in.
Please tell us your name.
My name is Shifty Wise.
Where do you live, Miss Wise?
I live in Parton County.
And do you know the defendant, Leslie Lovinggood?
I do. I know him very well.
How do you know him?
We were cellmates together at the Parton County Detention Center.
And when was this?
Over the summer.
Now, why were you in the Parton County Jail?
That is a very long story. But apparently, if you share a couple passwords on farmersonly.com with people who aren't farmers, it's considered identity theft. So I was in there for some trumped up charge for $60,000.
Now, you said you know Leslie Lovinggood from jail. Did you ever spend time with him?
We were cellmates, so we spent literally all of our time together.
Now, being cellmates, did you ever speak?
Yeah, well, at first our relationship was kind of rocky, but over time there's not much else to do, so we started talking.
And what did you talk about?
Normal stuff, your family, your favorite food, stuff like that, and then she told me why she was in jail.
And why did he tell you he was in jail?
He said, I'm only in here for some road rage thing.
And what did you say to that?
I said, what you mean?
And what did he tell you in response?
He said, I only fired a couple of shots to scare them off, whoever it was.
And did the defendant tell you why he fired shots at another driver?
He said that they had cut him off the road earlier.
Can you please repeat yourself slower?
He said they had cut him off the road earlier and he was angry.
Now, after he confessed this to you, what did you do?
I wrote a letter to the DA telling them exactly what I'm telling you here in court.
And did you ever speak with the DA?
I did. Me and my lawyer met with them.
Now, earlier you mentioned a $60,000 bond. Was your lawyer working to get this lowered?
My lawyer had been working for months to get this bond lowered.
And was it ever lowered?
Yes, it was lowered to $1,000, and that's how I was able to get out.
Now, did the district attorney offer you anything in terms of your identity theft charges in exchange for you coming here today?
No.
Did anyone offer you anything in exchange for your testimony?
No, I didn't get any of that.
And do you see Leslie Lovinggood, the defendant who confessed to you, in this courtroom today?
I do.
Can you please point him out?
He's over there in the green tie.
Thank you, Ms. Wise. No further questions.
Cross-examination, Your Honor. Ms. Wise, in 2014, you were convicted of shoplifting.
I was.
Objection, improper character evidence.
Response, Your Honor. Rule 609 is an exception to Rule 404, improper character evidence, and it says that criminal convictions are admissible so long as they are a felony or a crime of dishonesty, and if they're being used to impeach the witness's credibility, which is what I intend to do.
Your Honor, shoplifting is not an act of dishonesty, and considering Ms. Wise actually pled guilty to this charge, she did not lie about it, and since we can't objectively determine this, whether or not it is dishonest, this is inadmissible.
Response, Your Honor. Rule 609 defines a crime of dishonesty as involving deception. Shoplifting is definitively deceptive. You're dispossessing someone of their own property when you have no honest right to do so.
Your Honor, we stand by our objection. I think that, and my counsel agrees with me, that taking something from someone, while definitely a crime, is not dishonest, and we stand by our objection.
The objection is, do you have any response?
Yes, I was not saying that it was not a crime of dishonesty. I maintain shoplifting involves deception.
The objection is overruled. I do think that shoplifting falls within the definition of crime of deception, and I'm going to allow the questioning. Thank you.
Give me that.
I'll ask that again, Ms. Wise. In 2014, you were convicted of shoplifting, weren't you?
Yes, that was the Walgreens. See, I meant to take the pen, but the pen was connected to the cash register, so when I pulled on the pen, the cash register name came with it.
Ms. Wise, I'll ask you to do your explaining on redirect.
Okay.
Just to be clear, you've been convicted of shoplifting 4 times?
Yes.
That's right. But despite that, you're asking the jury to believe you're telling the truth today when you say that my client, a man you just met, confessed to you. That's your story?
Because I am telling the truth, yes.
Well, that story's awfully convenient for you, isn't it?
I'm sorry?
Well, isn't it true that when my client supposedly spilled his guts to a stranger, you were in talks with the district attorney to get your bond lowered?
Number one, we aren't strangers. We were friends because we were in jail for together. Or I don't know friends, but we weren't strangers. We have been talking for a while. And number two, the bond lower didn't have anything to do with my meeting.
I understand what you're claiming for today, ma'am, but just to be clear, you didn't know Mr. Lovinggood until y'all became cellmates, right?
No, not until we became cellmates.
And you had been in talks with the district attorney to get your bond lowered for quite some time, like you said earlier.
Yes.
And after Mr. Lovinggood supposedly gave you this information, you suddenly had leverage for your bond negotiations, didn't you?
Leverage?
Well, let's just make the timeline clear here. You've been in talks for months, right?
Yes, that's correct.
Unsuccessfully.
Well, they hadn't, I don't know what they were doing behind the scenes, but they didn't tell me anything.
Your bond hadn't been lowered.
It had not been lowered.
And then you write this letter to the district attorney on December 10th. correct?
Yes.
And within the span of 15 days before Christmas, your bond's been lowered from $60,000 to $1,000, right?
Yes, they lowered my bond.
Now, the fact of the matter is, you didn't get all your information about this case from Leslie Lovinggood, did you?
No. Or Billy Balding was the only thing that I got, but yes.
It's your testimony you learned the name Billy Balding from another source?
I'm sorry?
It's your testimony you learned information about this case from sources other than
Leslie told me that she shot at somebody.
Well, just to be clear, do you have other sources than Leslie Lovinggood about information in this case?
Look, I was told to stick to my testimony, but I can go outside of it if you want me to.
Let me ask you this. Did you get all of your information about what you said about the confession from Leslie Lovinggood or not?
Do you want me to go outside of my testimony?
I'm asking you to answer my question with a yes or no.
So I can't go outside of my testimony? So after Leslie had confessed, I talked to my lawyer, and my lawyer looked up the public records and found Billy Balding's name.
That's exactly right. You learned information about this case from your lawyer, didn't you?
The name Billy Balding, yes.
So for all this jury knows, you could have learned all your facts about this case from your lawyer and concocted this story.
Objection. This is speculation.
The witness is perfectly fine to answer with a yes or no. I'm not calling for any speculation.
He has no place to speculate whether or not she made all of it up, considering she has just testified that she heard from Mr. Lovinggood.
Your Honor, if the witness made it all up, she's very perfectly allowed to say no. My question is not calling for speculation.
I'm going to sustain the objection. Let's move on, counsel.
Let me ask you this, Ms. Wise. If you got information from your lawyer, this jury doesn't know whether you got all of your information from your lawyer, do they?
I got the name Billy Balding from my lawyer,
But you might have gotten other information, right?
but I didn't.
The jury just has to believe you're telling the truth when you say you got this information from one source and the rest from my client, right?
Yeah, because I'm telling the truth. They made me raise my hand and everything.
The jury has to believe you, a person who's been convicted of 4 crimes of dishonesty, right?
Yes, because I'm telling the truth.
No further questions, Your Honor.
No redirect, Your Honor. The state rests, Your Honor.
Just give me 1 second to put this mic on, Your Honor.
First time with a mic in a courtroom, to be honest with you.
Okay, there you go. Oh.
May I proceed, Your Honor?
Whenever you're ready, you may call for
The defense calls Ricky Rogers to the stand.
Yes.
Please tell the jury your name.
Well, my name is Ricky Rogers, but most people just call me Rifle. I'm kind of folks saying I know more about guns and bullets than them fellows Smith, Wesson, and Colt put all together.
What is your occupation?
I own the RRR shooting range over yonder on Sophia Lane. That stands for Rifle Ricky Rogers, in case you didn't put 2 and 2 together there. I run and operate the range as well as teaching the Tennessee State Police on firearms, ammunition, and trajectory analysis.
Do you have a curriculum vitae or CV that summarizes your education, training, and experience in the field of firearms and ammunition?
Yes, sir, I do.
Would you recognize that CV if you saw it for today?
I would.
Your Honor, Correction Trust Counsel, Exhibit Y. Here you are.
Thank you.
The prison books. Can you identify Exhibit Y for us there?
Yes, sir. This here is my resume, or curriculum vitae, as you'd call it.
Does it accurately and completely list your education, professional experience, courtroom experience, lectures, publications, and organizations?
Yes, sir, it does.
Did you adopt the contents of Exhibit Y as part of your testimony in court today?
I sure do. Yes, sir.
Your Honor, the defense offers Exhibit Y into evidence.
No objection, Your Honor.
And at this time, we also offer Mr. Ricky Rogers as an expert in firearms and ammunition under Rule 702.
Also no objection, Your Honor.
Mr. Rogers, have you identified and examined the firearm that was allegedly used in this case?
Yes, sir, I have.
Would you recognize that firearm, the magazine, the bullets inside?
I would, yes, sir.
Your Honor, giving the opposing counsel exhibits L, M, and N. I believe exhibit L is already in evidence. Can you identify those exhibits for us there?
Yes, sir. Exhibit L is a photograph of the firearm I examined for the case, a Sig Sauer P239 9mm handgun. Pretty standard. Exhibit M is a photograph of the magazine that was found in that firearm. And Exhibit N is a photograph of the bullets that were found in that magazine.
Are those fair and accurate depictions of the gun, the magazine, the bullets that you examined?
Yes, sir, they are.
Your Honor, the defense offers exhibits M and N in evidence.
No objection, Your Honor.
Now, Mr. Rogers, we heard testimony earlier in trial today that Miss Spaulding saw 2 bullets fly by her car. To the best of your expert knowledge, is that possible?
No, sir. That ain't possible. Can't see a bullet after it's done firing from a gun. Not a regular bullet, anyhow. Now, they do make what they call tracer bullets, and those you can see.
What exactly are tracer bullets?
Well, if you'd ever seen movies from the war, you might have seen what I'm talking about. Fire jets is always firing what looks like little orange lines so the pilots can see where they're firing. Tracer bullets have a small little pyrotechnic charge in them that gets burned real bright when it's fired, kind of like a firework on the 4th of July. And when that charge gets burning, it becomes bright enough to see with the naked eye.
Now, these bullets you examined, were they tracer bullets?
No, sir. Wasn't none of them tracers.
Were they some other kind of bullet that could have been seen with the naked eye?
No, sir. They was the wrong kind of bullets to be seen with the naked eye.
Mr. Rogers, Ms. Spaulding also testified that the bullets were bright enough to see at night. Do you remember that?
I do remember that, yes, sir.
What do you make of that?
Well, that sounds like a tracer bullet to me, sir.
Thank you, Mr. Rogers. No further questions at this time, Your Honor.
Mr. Rogers, you were hired by these defense attorneys.
Yes, ma'am, I was.
They paid you to inspect the firearm found on the defendant's person after he was arrested,
Yes, ma'am, I was paid for my expertise.
as well as the bullets inside that firearm.
Yes, ma'am.
They're also paying you to testify in front of this jury here today.
They are.
Now, Mr. Rogers, I want to be very clear on what exactly you're an expert in. You're an expert in firearms and ammunitions.
Of course.
You have specific expertise in bullet trajectory analysis,
That's correct.
as well as shooting scene reconstruction.
That is also correct, yes, ma'am.
Now, you're aware that this case involves a shooting on a roadway.
Not before today, no, ma'am, but hearing what I heard today, it seems like that.
And you're also aware that another ballistics expert has already concluded that this shooting resulted in damage to a vehicle.
I believe I saw something like that earlier today, yes, ma'am.
But the defense never asked you to give any opinion as to whether or not that damage was in fact caused by a bullet.
No, ma'am, I didn't see no damage before.
And therefore, you have no basis to disagree with the other ballistics expert.
No, ma'am, I've never seen any damage on anything.
Now, Mr. Rogers, I want to talk about your inspection of this handgun. The gun was a P239 Sig Sauer 9mm handgun.
That's correct.
You can tell us that it had an 8-round magazine
Yes, ma'am.
with only 5 rounds in it
That's correct.
and no round in the chamber.
Yes, ma'am.
But you can't tell us if this gun had been recently loaded, how many bullets were originally put in it.
No, ma'am, I cannot.
You can't tell us if it had been recently loaded, if someone had manually racked the chamber and gotten rid of the live cartridge.
No, ma'am, I could not.
You can't even tell us if someone had loaded it, who that someone was.
No, ma'am, I don't have that information here for y'all today.
But you can tell this jury that manually racking a gun and removing that live cartridge is a way to safely store a gun.
Yes, ma'am, it is.
And you can also tell this jury that the bullets you inspected in this case were blazer brass bullets.
Yes, ma'am, they were.
And you were in the court when Trooper Thomas testified.
I was.
You heard her testify that the scrape she observed on Billy Balding's car was metallic and brassy in color.
I did hear that. Yes, ma'am.
Thank you. No further questions.
No, Your Honor.
This is this. This is yours. That was like short and sweet.
Your Honor, the defense calls Mr. Red Lovinggood. Mike's there.
Mr. Lovinggood, as you're approaching, I'll remind you that you've already been sworn in today, and to tell the truth today.
Yes. Stay up.
Sir, please introduce yourself to the jury. Spell your last name for the record.
Yes, sir. Well, my name is Rufus Lovinggood. Last name spelled Lovingood. But nobody other than my mama, may God rest her soul, ever call me Rufus. Everybody just call me Red.
Sir, why did they call you that?
That's a good question. Maybe it's because I'm Irish.
Please tell us your age.
Well, now look here, son. Age ain't nothing but a number, and well, I don't feel no 88 years old, but I am 88 years young.
Are you retired?
I suspect so. I spent my more able years down in Memphis, and by day I worked in purchasing for this wheelchair factory. They always told me I was a man who knew how to get things. But by night I played the piano over at Uncle Handy's Blue Alley. Well, boy, you should have seen me tickle those ivories back in my day.
Sir, do you still live in Memphis?
No, sir. My family moved me out here to Medina a few years back, a place called Whispering Pines. They say I'm too old to live alone.
How do they treat you in Whispering Pines?
Objection, relevance.
Your Honor, I'm just establishing some background for this witness to tell the jury.
Your Honor, if I may, they have established quite a bit of background, and we ask that they move on to their next line of questioning.
And counsel, I'm having a hard time seeing how this is relevant. If you have anything else to offer in that regard on why it's relevant, I'd be glad to hear it. Otherwise, I'm going to sustain the objection.
Yes, Your Honor, this is my final question on this matter. But I'll move on.
Please do.
Sir, do you know why we're here in court today?
Oh, yeah, I suspect they say Leslie done did something.
Do you know Leslie Lovinggood?
Well, of course I know Leslie. He's my grandson.
Do you speak with Leslie often?
Yeah, Leslie calls me on Thursdays. Every Thursday after dinner.
Do you remember if your grandson called you on Thursday after dinner on June the 10th, 2021?
June the 10th. Yes, sir, I do believe so. If that's a Thursday, then yes, he did call me.
Does he call you on a cell phone, or do you have a landline?
Well, I have what they call a mobile telephone. And, well, my number is 654-856-9874.
Your Honor, I'm showing opposing counsel what's been marked as Exhibit O. I'm now approaching the witness with Exhibit O. Your Honor, like a copy? Now, sir, do you see your grandson's phone number listed here?
Oh, I'm sorry. You want me to read this?
Yes, sir.
Oh, shucks. All right. I'm sorry, sir. What was your question?
Not your phone number, but your grandson's phone number. Is it listed anywhere in this document?
Oh, yes. And you know what? You're right. I see it twice to be exact. And, well, he did call me once before and again after dinner.
Your Honor, at this time, we offer Exhibit O into evidence.
No objection, Your Honor.
Now, sir, if you look at the time he called you after dinner, what time does it say that this phone call began?
8:12 p.m.
Does it say here what time the phone call ended?
Well, not explicitly, but with the simple math right here, it's 8:12 and 44 minutes, and, well, 8:56 finish.
So were you on the phone with your grandson the entire time from 8:12 p.m. to 8:56 p.m.?
I was.
So then did you hear were you on the phone with your grandson at 8:30 p.m., I'm assuming?
Yes, sir, I was.
Well, sir, the state of Tennessee is alleging that your grandson assaulted someone around that time. Based on what you heard on the telephone that night, does that sound possible?
While we were on the telephone? Go on now, I ain't hear nothing like that.
Well, why don't you tell the jury what you did hear on the phone call that night?
Leslie and his Mustang. You know, he would just rev the engine up real big, you know, just skylarking it.
What do you mean by that?
Well, you know, Leslie and his Ford Mustang, he would just rev the engine up real big and just well, they used to call it skylarking back in my day, but he would just rev the engine up real loud, and then he'd say, listen to her run red, and well, she was purring like a kitten too.
Now, sir, you say that your grandson was revving his engine on the phone call that night with you. Do you know if he was revving his engine at another driver?
For another driver? No, not for another driver. He was revving the engine up for me so that I could hear it. Now, as loud as it was, you could probably hear it from a mile away, but, you know, he was revving it up for me and asking me if I could hear it.
Did your grandson ever interact with another driver while on the phone call with you that night?
Well, he did yell about another driver cutting him off once.
And when he yelled about this driver cutting him off, did he do anything in response, like rev his engine, for example?
No, sir. Like I say, he was just revving the engine up for me so that I could hear it and was asking if I could hear it on the phone.
Sir, this may sound crazy, but did you hear any loud bangs while on the phone call that night? Like gunshots, for example?
Gunshots? Heavens no, I ain't hear no bangs, no gunshots, no nothing like that, no, sir.
Thank you, Mr. Lovinggood. I have no further questions, Your Honor.
Mr. Lovinggood, if you'd go ahead and take a look back at Exhibit O.
Yes, ma'am.
So if you look at the third column, the fourth column from the bottom, it says, can you read me that time there? It says under connection date time.
Under connection date time?
Yes, sir.
It says 8:12 p.m.
Oh, no, I'm sorry. 2 rows up from that.
Oh, 2 rows up. 5:23 p.m., ma'am.
And can you tell me how long that call lasted?
Well, this phone call lasted for 4 minutes.
4 minutes, so it was pretty short.
Yes, ma'am.
And this call was short, and on this call, your grandson seemed frustrated, probably.
Yeah, he had called me about some misunderstanding and things like that.
Objection, Your Honor. This question calls for improper character evidence. The general character evidence here is that he was angry earlier, 3 hours before the alleged shooting. We're trying to prove an action in conformity with that character trait.
Your Honor, we are not trying to prove action in conformity, but rather under 404B go into motive and state of mind, but we aren't going to discuss the details of what had happened with the police, simply that he was arrested.
If I may, Your Honor, 404 not only excludes specific instances of conduct, which she says they're not going to get into, but also just character evidence generally. The character evidence of Mr. Lovinggood being angry earlier that day is absolutely trying to prove he committed this case of aggravated assault.
Your Honor, this goes to motive and state of mind, showing that he was angry earlier, which lasted into the evening. We're not saying that because he was aggressive earlier, he was violent towards another driver, because the jury would be far too inclined to take that as character evidence. We're showing his motive and his state of mind.
Go ahead. You have anything else?
Well, Your Honor, if they are trying to prove that anger was sustained the entire time, well, they can't do that without going inside Mr. Lovinggood's mind, which Mr. Lovinggood certainly can't do. And furthermore, there's no foundation about anything between this prior phone call and this phone call later that night, so they can't connect that anger was sustained. They're 2 separate instances being used for propensity purposes.
Your Honor, unfortunately, the human mind doesn't work like an isolated vacuum. You know, if you get frustrated earlier and you have an extremely aggravating situation of getting arrested, it's not like he was just completely calm and fine. So we are not using his arrest earlier to show that he could have been arrested later, but rather to point towards his state of mind during that entire evening.
The objection is overruled. I think the proximity and time of this evidence does show that it's being offered for motive rather than to show conformity and character and conformity therewith. You may proceed.
So, without getting into any details, you heard in this courtroom today that your grandson was arrested.
Yes, ma'am, I heard something like that.
But then later on this evening, he seemed fine on the phone.
Oh, yeah, Leslie seemed like his normal self and things like that, and he was just so excited to let me listen to his new car.
To let you listen to his car, so he was revving it loudly.
Yes, ma'am, the car is a Mustang, and well, he was revving the engine up.
And you could hear this loudly and clearly through the phone.
Oh, yes, the car was purring like a kitten.
And then at one point, he got cut off in traffic by another driver.
Yeah, he had yelled about another driver cutting him off once. You know, that's the reason why I stopped driving 10 years ago. You know, everybody drives like madmen these days.
So he yells at a driver, temper flares, but then just as quickly cools down.
Objection, Your Honor. This assumes facts, not evidence. Mr. Lovinggood hasn't testified that the temper of Leslie Lovinggood's mind was flaring, and that would call for speculation.
Your Honor, this is a rationally based perception that if someone is yelling at another person and then stops yelling, that their temper flared and then fizzled out.
Your Honor, Mr. Lovinggood hasn't testified to that yet. If she wishes to include that in the phrasing of her question, Mr. Lovinggood must testify to that first.
Your Honor, I'm sorry.
Go ahead.
He just said that he yelled at another driver.
I'm going to sustain the objection. You can lay a foundation if you'd like to proceed with this line of questioning. Otherwise, let's move on.
Yes, Your Honor. So, to go back, he yelled at another driver.
Yes, ma'am, he did yell about another driver cutting him off.
About another driver cutting him off in the road.
Yes, ma'am.
Probably yelled a few choice words.
You know, he yelled about another driver cutting him off. You know, I mean, the car is new and well, I mean, who would want their new car to get hit by another driver?
So he yells, and then we move on.
Yes, ma'am.
And you didn't hear anything else suspicious after this time?
No, ma'am, I didn't. Like I say, he was just revving the engine up for me so I could hear it.
All you heard on this car was the revving of the engine, yelling, a little more revving, and no gunshots.
No, ma'am, I did not hear any gunshots. I just heard him revving up the engine. He was so proud of this new car and things like that. I was proud of him, too.
You were proud of him?
Yes, ma'am.
Because, sir, he's your favorite grandson.
Well, you know what, now that you put it like that, I guess he ain't got no choice to be my favorite grandson because he's my only grandson.
He's your only grandson?
Yes, ma'am, he is.
He's the only member of your family who visits you?
Well, no, that's not right.
It's not right?
No, ma'am, that's not right.
So your other family members visit you and take care of you?
Yes, ma'am, they do.
Your other family members call you regularly and care for you?
Yes, ma'am.
It is your testimony today that the rest of your family regularly cares for you?
Yes, ma'am, they do.
Are you aware that before you came here, you signed a statement?
Yes, ma'am.
And on this statement, you were sworn to tell the truth?
Yes, ma'am.
And you understand how important it is to tell the truth while you are under oath?
Yes, ma'am.
And you understand it is a crime to lie under oath?
Yes, ma'am, I'm aware.
And you are sworn in today under that same oath?
Yes, ma'am, I was.
Let the record reflect I'm showing opposing counsel a copy of Mr. Lovinggood's witness statement. And it's unmarked except for the sticky note. Mr. Lovinggood, I've underlined an area right here if you'll read silently while I read along. Leslie is my favorite grandchild.
Yes, ma'am.
Out of all my other family members living in the area, Leslie is the only one who visits or calls me regularly.
Yes, ma'am, you got it right.
So, your family members do not visit or call you regularly?
Well, no, the statement says that all my other family members living in the area, out of all my other family members living in the area, Leslie is the only one who calls and visits me regularly. I have other family members outside the area that call and visit me regularly, and I have friends and other people and things like that, so you read it right.
And you didn't think it would be important to include that you had an entire family that supported you?
Well, I do have a family that supported me.
Well,
I just said that Leslie was the only one living in the area that comes and visits me regularly.
Well, of all of your family in the area, if Leslie got arrested and taken to, if Leslie got convicted and taken to prison, she couldn't visit or call you anymore.
Well,
I'm sorry,
Well, you know, he can't visit me anymore, but there's a phone in the jail.
And he can't care for you, can he?
No, ma'am, he can't.
So you'll just have to be at the home care facility center?
Yes, ma'am.
No further questions.
No reading, Your Honor.
Thank you, Your Honor.
The defense calls Mr. Joe Trippin to the stand.
And I'll remind you that you've already been sworn in today and taken an oath to tell the truth.
Please introduce yourself to the jury and spell your last name for the record.
I'm Joseph Trippin, and that's T-I-P-P-I-N.
What do you do for a living?
I'm a supervisor over at the glue factory on Volunteer Parkway. You know, it's the one with the big blue dog out front. Blues Glues, they call it.
Tell the jury a little bit about yourself. Where are you from?
Well, my ma was a sixth-generation Tennessean, so, you know, I was born here too. But, well, my pops was from Brooklyn, so, you know, we moved back there when I was, when I was a toddler. So, you know, I grew up in the city.
When did you move back to Tennessee?
Oh, jeez, don't get me started. Look, about 5 years ago, my ma, God bless her, you know, her fourth husband died and she was a mess. So, you know, me and my wife Amber, we packed up our bags and bada bing, bada boom, I'm Tennessean again.
Sir, I'd like to talk about why you've been called to the courthouse. Do you know an individual by the name of Billy Balding?
Yeah, I know Billy. She's good people. You know, we works together at the factory.
How well would you say you know Miss Balding?
Oh, I know her pretty good. You know, we was partners on the mixing floor. So, you know, we spent a lot of time together. I mean, we're better to make a bond than a glue factory, right?
You mentioned your partners on the mixing floor. Were you working with Miss Balding on June 10th of last year?
Yeah, June 10th. You know, it's the day Billy had a little incident on the drive home. I mean, it's why we was all here, right?
Yes, sir. Do you remember anything unusual about the workday of June 10th?
Unusual? Well, yeah, you know, for one thing, that's the day Billy threw out a breakfast, and I mean, I was worried about it.
Why were you worried about that?
Well, you know, because she threw out a breakfast, I mean, I was just worried about the fumes, you know, because she was working on an empty stomach. I mean, the fumes is the whole reason we works in pairs at the factory.
Can you explain what you mean for the jury?
Yeah, you know, well, down on the mixing floor, they got us mixing around all the organic materials in these big round vats. And we got to heat it up, you know, and once it gets all oily and gooey inside, you know, that's when the fumes hit. So, you know, we works with a partner to make sure, you know, no one's falling over.
Is falling over something you've experienced or something that's happened at the glue factory?
Jeez, I mean, falling over ain't nothing. I mean, one time a guy fell into one of the vats. You know, I mean, I've gotten sick to my stomach. Some people start hallucinating things. I mean, it can be real scary.
Mr. Trippin, how long have you been working at the glue factory?
Let's see, you know, I started late 17, so I guess, you know, over 4 years now.
Based on your experience and training, is there any way to prevent the symptoms of being exposed to glue fumes?
Oh, yeah, you know, well, like I was saying, though, the most important thing, though, is making sure you got food in your belly. Because, I mean, you know, you don't want anyone working a shift on an empty stomach here.
Now, at any time on June 10th, did you see Miss Balding show signs of being affected by the glue fumes?
You know, not until the afternoon, but, yeah, I did.
Tell the jury what you saw.
Well, you know, Billy just seemed a little, you know, unsteady on her feet, you know, a little wobbly, you know what I'm saying?
Did you see anything else?
Yeah, you know, her eyes were glassy, for one thing. And towards the end of our shift, she started just muttering and mumbling like crazy talk, you know?
What do you mean when you say crazy talk?
Well, you know, it's not the stuff she was saying, it's just kind of how she was saying it. I mean, I just couldn't understand it. She said, you know, Josiah, and you gotta ship up a shape out. I mean, it sounded like she was talking in her sleep or something.
Mr. Trippin, what did you think when you saw all of this?
What am I thinking? I'm thinking, oh, for the love of Mike, why me, right? Because, look, when you see a coworker showing signs of glue problems, company policies, you gotta go over and report it to the manager. And this is happening right as our shift's about to clock out, so I'm thinking I'm gonna be pretty late for dinner.
So, did you stay late after work and report Miss Balding's condition to management?
Well, yeah, no, you know, and I got lucky, see, because, you know, one of the other coworkers came over and she kind of saw what was happening and she asked me if Billy been acting like that all day. I just told her what I know, and she went over to handle it. You know, the glue factory's full of great people like that. You know, we all stick together.
Thank you, Mr. Trippin. I have no further questions, Your Honor.
Cross-examination? Now, Mr. Trippin, you just testified in court today how Ms. Balding was acting on June 10th.
Right, yeah.
You talked about how she was working in front of those glue fumes.
Exactly.
And you were her partner on the mixing floor.
Yeah, we was working it together. You know, they got the buddy system down there.
And you were working the same distance away from those glue fumes as Ms. Balding.
Yeah, we mixes around the stuff in the vat, so I guess we was, you know, right next to the glue.
And you yourself would have to admit that you're no stranger to glue sickness.
Yeah, you know, I mean, those rookie days were crazy. I mean, you know, you never expect it to be so bad when you walk in there, but that stuff does not smell good, let me tell you.
Now, I'd like to talk a little bit about your shift on June 10th. So you worked the same shift as Ms. Balding.
Yeah, like I said, we was partners.
Within a few feet of her.
Right, yeah.
And you testified that she appeared to be having glue sickness.
Yeah, you know, all the stuff I was saying, like she was, you know, unsteady on her feet, eyes were glassy, all that stuff.
Actually, Mr. Trippin, in your words, her eyes were a little glassy.
Right, yeah, same thing.
Now, you submitted your time cards for the week of June 10th to the court.
Right, mine and Miss Balding's.
And you would recognize them if I showed them to you?
I would, yeah.
Let the record reflect I'm showing opposing counsel an unmarked copy of Exhibit Z and AA. May I approach the witness?
Thank you.
Mr. Trippin, those are Exhibit Z and AA.
I just got one of them, but this is Z.
If you turn the page, AA is on the next one.
Oh, yeah, sorry. Yeah, AA.
And those time cards fairly and accurately reflect your shift from the week of June 10th.
Yeah, both. It's mine and Billy's.
Your Honor, at this time we offer Exhibit Z and AA into evidence.
No objection, Your Honor.
Now, Mr. Trippin, you took a lunch break that day.
Yeah, I did. I headed over to the Buca de Beppo downtown. That's why I went.
And you clocked out for your lunch break at 1:57 and then clocked back in at 2:27.
Yeah, that's what it says.
And Billy Balding also took a lunch break.
Yeah, you know, union requires us all take break at 2 p.m. about, you know, we gotta be out for 30 minutes.
Yeah, she took a lunch break from 2:02 to 2:32.
Yeah, that's what it says.
Now, you can't tell us what Miss Balding ate for lunch that day.
Yeah, I wasn't with her, like I'm saying. She doesn't like the Buca de Beppo. I didn't go with her.
You can't tell us how much she ate for lunch that day.
I wasn't with her. I really can't tell you anything.
All you can do is tell us that she did, in fact, take a lunch break.
Well, yeah, that's what it says in the cards.
Now, Mr. Trippin, I would like to talk about glue sickness. So as you testified a minute ago, your employer has a lot of policies in place for glue sickness.
Right, yeah.
Because glue sickness is dangerous.
It is, yeah, for sure.
And those who have glue sickness can be hurt.
Definitely.
Even killed.
Yeah, you know, that one guy fell into the vat, didn't go over well.
Now, perhaps the most important of all of these policies is that if an employee witnesses a coworker experiencing signs of glue sickness, you're required to report it.
Right, yeah, you know, someone's got to go report someone another person if they're showing signs.
So surely, Mr. Trippin, since Miss Balding was, according to you, showing signs of glue sickness, you can tell this jury that you reported it.
Nah, it's like I'm saying. The coworker came over and I talked to her about it. I thought she was going to handle it.
That's right, Mr. Trippin. The reality is you did nothing.
Well, I didn't do nothing. I talked to the coworker about it, and you know, I trusted her to report it to the manager.
And Mr. Trippin, if you are telling the truth about Miss Balding having glue sickness, then you're admitting that you violated company policy.
I mean, look, if I didn't think the other lady would report it, believe me, I would have done it myself. I mean, I didn't violate company policy. I left it to her.
Mr. Trippin, the policy was that if an employee witnesses a coworker experiencing symptoms of glue sickness, you're required to report it.
Well, yeah, I mean, someone's got to report it. You don't need like 3 people walking in the office.
And isn't that what you said today in court, that Miss Balding was showing signs of glue sickness?
Yes, ma'am.
So then you did, in fact, violate company policy.
No, ma'am, I left it to the coworker, because it's like I said, only one person's got to go report it.
So the symptoms of Miss Balding's glue sickness weren't significant enough to you to report them?
No, they were. I'm telling you, I told the coworker about this, and to be honest, I thought she was going to report it.
But you didn't.
Look, I wish I had. You know, maybe we wouldn't be here now. I really thought she was going to do it.
No further questions, Your Honor.
Brief redirect, Your Honor.
Mr. Trippin, why didn't you report Ms. Balding's condition to management?
Well, it's like I keep saying, you know, policies, one person's got to go report it to the manager. And, you know, I saw the coworker talking to her. I thought, you know, she might as well go handle it.
And did you believe that Billy Balding was showing signs of glue sickness?
Of course, yeah. It's like I've been saying this whole time.
Thank you, Mr. Trippin. No further questions, Your Honor.
No recross, Your Honor.
Defense rest, Your Honor.
Before I give my closing, may I mess with the mic real quick? Your Honor, before I begin, I ask that any time remaining be added to rebuttal.
Up to a minute, Your Honor.
So yeah, you may reserve up to a minute.
Yes, Your Honor. Think about the distance between my two fingers. It's maybe about what? 12 inches? Now looking at it here in this courtroom, it doesn't seem all that significant. But to Billy Balding, on her drive home from work on June 10th, 2021, this was the most important thing in the world. It saved her life. It saved her 3 school-aged children from becoming orphans. This tiny distance was literally the difference between a 9mm bullet striking Miss Balding's side view mirror and the side of her head. But do you think the defendant ever considered this, even for a second? The moment the defendant secured his grip on his loaded 9mm handgun and pointed it out the window, the defendant didn't take a breath or take a moment to think. Instead, the defendant took aim and fired. That's because when the defendant took the wheel, anger took control. Now in the law, we have a name for that. We call it aggravated assault. It's when a person knowingly, intentionally, or recklessly uses a deadly weapon to cause another person reasonable fear of imminent bodily injury. Today, we've proven beyond a reasonable doubt that that's exactly what the defendant did. So let's walk through how we did that. First, there's no question Miss Balding was afraid. There's really no fear any greater or more imminent than fearing you might be moments away from death. So that leaves 2 more things. Next, we know a deadly weapon was used, specifically a 9mm handgun. The trooper found it on Leslie Lovinggood's person just days after the shooting. And we also know that the fact that a handgun was used is completely verified by the only witness whose memory and eyesight can never be called into question: science. We know that based off of the distinct pattern, shape, and color to the damage of Miss Balding's side view mirror, it was caused by a bullet. And what's the defense's response to this? They didn't even try and offer another reasonable explanation. And you can bet, if there was any other reasonable explanation given the physical evidence, the defense's hand-picked, paid expert would have been happy to tell you all about it. But the simple truth is that there's no room for reasonable doubt anywhere that that damage did not come from a bullet. So that leaves one more thing. Did the defendant do it? To answer that question, think of this. How many things would have had to have been mere coincidences for it to have not been the defendant? Ms. Balding testified today that one of the things she remembers about the shooter was that he was wearing a bright orange hat, which is exactly what Leslie Lovinggood was wearing at a traffic stop just hours before the shooting. A traffic stop where the defendant was angry. And when the defendant took the wheel, that same anger took control. And if that's not enough, you heard from the defendant's months-long cellmate exactly what the defendant told her. Yeah, I'm in here for some road rage thing. I fired off a couple of shots to scare them, whoever it was. And what's the defense's response to that? Predictably, they've tried to get you to believe that Shifty Wise just made it all up. But they're missing the obvious. If Shifty Wise just made it all up, how did she get so much completely right? Not just that there were shots fired, but a couple. Not just a couple shots fired, but shots fired in a road rage incident intended to scare another driver. Either the defendant is the most downright unluckiest person to be caught up in some grand scheme of coincidences, or the defendant is guilty. That's because when the defendant took the wheel, anger took control. But now the control is in your hands. We ask that you find the defendant guilty. Thank you. I love you.
Please support. Opposing counsel. Members of the jury. Balding. That's about as close as Miss Balding was. The supposed car higher. But what can she tell you? She can tell you that the shape of the eyes, the size of the eyes, and when she tried to tell you the color of the eyes, members of the jury, that's a fact she made up in court today. A fact that she didn't once tell Trooper Thomas or tell any of the state department. The reason she made it up, and the reason that Trooper Thomas lied to you, is because they know they've got the wrong car, the wrong bullets, and the wrong explanation. But before we go any further, I want to be very clear that Leslie Lovinggood is not required to prove his innocence to you today. Under the law, he is presumed innocent. And for you to find guilt, the state must have met its burden and proven its charges beyond a reasonable doubt. Members of the jury, that is the highest burden in our criminal justice system. It requires the state to prove to a moral certainty that Leslie Lovinggood recklessly fired a gun and scared Billy Balding. The state has failed to prove that anyone fired a gun at Billy Balding. Think about what you just heard from Joe Trippett. He provided you the explanation that opposing counsel thinks we're missing. The explanation is that Billy Balding was breathing powerful blue fumes for 10 hours on June 10th. He was showing signs of blue sickness, a symptom which is hallucination. Are you certain, beyond a reasonable doubt, that Leslie Lovinggood fired a gun? Or was Billy Balding just hallucinating when she saw two bullets fly? And just asked himself, why didn't Trooper Thomas recover any bullets or find any shell casings when she searched Sophia Lane? Now, they're telling you about science. Members of the jury, where's the scientific evidence? The scrape on the mirror wasn't just caused by another car in a parking lot. Where's the scientific evidence testifying the composition of that metal scrape? There's none. That brings me first back to the proof today, that Leslie Lovinggood owns the wrong car. Billy Balding testified for certain that she saw a blue four-door car the night of June 10th. You learned in trial today that my client doesn't drive a blue four-door car He drives a two-door black Ford Mustang. Wrong car equals reasonable doubt. Trooper Thomas knew that. Which is why when you heard her ask questions on cross-examination, she tried to wiggle out by lying and by contradicting the very facts she wrote in her witness statement. By contradicting the very facts that she wrote in her affidavit of complaint when she charged her. That brings me to fact number 2. Leslie owns the wrong bullets. Even if Miss Balding wasn't hallucinating on Sophia Lane, there's still a big problem with the state. Mr. Rogers testified that only one kind of bullet can be seen by the naked eye after it's fired from a gun. A tracer. When the police confiscated my client's gun, they didn't find tracer bullets inside. They found more bullets. Wrong bullets equals reasonable doubt. Finally, members of the jury, the state's got the wrong explanation. Red Lovinggood was on the phone with Leslie Lovinggood at the exact time the state alleges the crime occurred, but heard nothing that even resembled a gunshot. And the state's response to this is that Billy Balding identified my client as shooter. But how could Billy Balding have reliably identified anybody? Billy Balding couldn't describe the shooter's skin color or hair color or height or weight or whether the shooter was even a man or a woman. The only other physical characteristic was an orange hat. Members of the jury, we are in Tennessee, the volunteer state, the state where the top schools, school colors are orange. Now, the last fact they're trying to prove, asking me to ignore the other holes in their case, is to rely on the testimony of a jailhouse snitch. A jailhouse snitch whose bond was conveniently lowered from $60,000 to $1,000 just after she sent a letter to the DA. You also heard this jailhouse snitch had multiple sources at the time of her writing the letter, which means that there must have been some other source besides Leslie Lovinggood. Members of the jury, my client owned the wrong car and owned the wrong bullets. It's the state's explanation for what happened that's not just wrong, it's unacceptable. Thank you.
Rebuttal, Your Honor. What's so wrong with that car is the way it treated Billy Balding. What's so wrong with those bullets is the fact that they were ever shot at her. And what's wrong with the explanation is that the facts of this case show that Leslie Lovinggood is guilty. Thank you.
Thank you, counsel. We will recess for the jury to deliberate. Thank you. All rise. Okay, so So we have to wait a little bit longer. I will let the jurors now introduce themselves, and they will also provide a bit of feedback before the verdict is announced.
Well, good evening, everyone. My name is Quentin Thompson, and I am the Tennessee Bar Association Young Lawyers Division Vice President. And I am from Memphis, Tennessee. I work with Morgan, so I do personal injury work for the people. I just want to quickly say that this is the first time that I have judged mock trial in a few years in person, and I have always enjoyed judging mock trial. I did mock trial from high school to college to law school, and you all are just some of the best that I've ever seen. So congratulations, and like for me, all of you were spectacular, but I was really just blown away by Shandon, I believe is your name. You just blew me away. So substance, style, just overall quality, just rock star. Good job. But all of you did great.
Hi, I'm Terica Smith. I am the YLD immediate past president. I am an assistant district attorney in Jackson, Tennessee. Y'all did great. I mean, there are a few of you I would not want to go against me for. And I can tell that you guys work really hard. You have a great command of the rules of evidence. I think you could probably teach a few attorneys how to practice with a few things. So, great job.
Good evening. My name is Tasha Blakeney. I practice in Knoxville, one of those places where there are lots of orange caps. Lots of people, lots of those. I am currently the president-elect of the Tennessee Bar Association. So I have been around mock trial for a long time, coming up through the ranks, having been a past president of the Young Lawyers Division and now I'm a president of the TBA. So I've been a coach myself when I was a lawyer. I have been a scorer and a judge, and I became a mock trial parent myself. I have a daughter who's in law school now. So what I can tell you is that I've been around mock trial a long time, and when I say that this was great, I really mean it. Like, I've seen a lot of competitions, seen a lot of mock trial, and you all were fantastic. And I didn't know as I was doing my scores who was going to win until I got the calculator out, because it was so close to me. And on behalf of, I think, all of us, and on behalf of the TBA, I wish we could send you both to the national competition. I do, because I thought you were both that great. So thank you.
Good evening. My name is Courtney Simmons. I practice in Jackson, Tennessee. I have my own firm, Casey Simmons and Bryant. I do criminal defense and family law. So it was refreshing to see a criminal defense case. I've been in mock trial all my life. I've competed, I've coached, I've had teams come to this competition, and I've scored and everything like that. So I'm a little more critical, honestly and truly, of how everyone performs, just because I have my own high expectations on how you guys should do it. You guys did amazing. I'm not, you've done far better than teams that I've coached. So that's just, and that's saying something, because my teams are awesome, but you guys did amazing. I thought you guys did great with objections, going back and forth. The only thing I would say is just be honest. Stick to what it says in the thing. Don't be fair. That's the biggest thing to learn. Just always make sure that you're being fair in following the rules of the mock trial uniform first. Because in real life, you'll get caught up, and that's not what you want. So just keep that in mind. But I thought you guys did amazing. And defense, y'all's witnesses, I love them. I absolutely love them. I think witnesses are amazing. So good job.
Good evening. My name is Sherry Edwards. I am the president of the Tennessee Bar Association. I'm the only thing standing between Tasha being president and June. I am giving her a healthy. If I let her take over. I'm from Brentwood, Tennessee. I'm a corporate attorney. I've always been a corporate attorney. I have not actually argued a case since I did new court in law school in this very courtroom. And I would run to the ladies' room before I would have to speak, because I would get so nervous about speaking. I did not have the poise and the presence that you all have. And I just really commend you for how you put on your case, how you conducted yourself, the presence that you brought to that. I have to agree, the witnesses were amazing. I've got to ask you, are you really from Brooklyn?
We'll find out.
Because, you sound like Joe Pesci a little bit. But no, you all did great. I wish we could, like I said earlier, send you both teams. It was an amazing job. So thank you.
David Beal. I practice in Franklin, criminal defense. So again, I also think this is a criminal problem. Although I've been mistaken for high school students, somebody asked me to sit over there. I've actually been scoring and been involved in the TBA in this competition since 2006. So I've seen it a lot over the past few years. And this was, I think, my favorite round I've seen. You guys just did a phenomenal job. You controlled the backs, you controlled yourselves, you were addressing us. Great, best eye contact I've had in any competition ever. Just knocked it out of the park. It was great. It was really entertaining. Bada bing, bada bang. It was great. So well done. So congratulations and good luck.
Sean Aiello, I'm a Middle Tennessee governor for the Young Lawyers Association of the TBA. I practice also in Franklin, civil litigation, so I'm in the courtroom several times a week, and I'd be happy to have you if you all with me. My comment can really roll down to one word, that's sportsmanship. As soon as we got off the bench, the first instinct for both sides was to immediately go over and shake the other side's hands. And if you can maintain that same level of collegiality and sportsmanship with the common member of the legal profession, we'll all do that for you. So thank you for that.
My name is Billy Leslie. I am the Young Lawyers Division president this year. I practice as an associate general counsel for the Tennessee Department of Commerce and Insurance. Again, you all, I said it earlier, you all have done a fantastic job. It was a great round. I enjoyed sitting here listening to you guys go back and forth. You were both very collegial with each other during the course with your objections and all that. That's very important. So, very good job. Thank you for participating in the competition.
I'm Justin Faith. I'm in private practice in Chattanooga. I do primarily business litigation and trust in the state litigation. No criminal work. I've been doing this many years, like many of the other jurors in this panel, and I thought this was one of the better rounds I've seen. You both had themes, you tied it together with opening and closing, and then you use it against the other team. You did great. Whether you decide to go to law school or not in the future, I know you all have bright futures ahead. So just thank your parents, thank your family for all the time it took to get to this spot. Good luck to all.
My name is Alex McVeigh. I am also from Chattanooga. I am the East Tennessee governor of the Young Lawyers Division of the Bar Association. I'm also a General Sessions Court judge I believe I'm the youngest judge still in Kansas State, Tennessee. So again, I just certainly think that you guys hopefully will not only be members of the legal profession, but also members of the Young Lawyers Division when you do become lawyers, as well as the Tennessee Bar. But I just want to say that kind of echo what everyone else said. I mean, I've 9 years schooling judge, not only in Chattanooga but here, and I will say this is the most impressive round I have ever seen in my 9 years. Congratulations to you both. Eye contact, not just in the round, eye contact, best eye contact I've ever seen in life. I can't look at you that long. I mean, you did it unbelievable. I will also say, witnesses, amazing. Defense, obviously. My favorite witness is actually Chippy Buck. I haven't really seen a moment like this where you literally asked, "Are you sure you want me to go outside?" Because you're allowed a little more leeway when you open the door and you asked about 3 times. So anyway, but obviously the defense witnesses and all the witnesses, you're not going to law school, I hope you're going some sort of theater, drama arts. Congratulations, guys.
Hey guys, Ross Smith. I'm an attorney here in Nashville, and it's not important what I do, but I'll tell you, you guys, one thing that you'll always have, and I want you to know this, I was visiting with Justice Campbell before this started, and this is actually the first time ever that she's been on the bench as a sitting Supreme Court justice. So lawyers, I think next Tuesday or whatever your case is, when they say we have the first case in front of Supreme Court Justice Sarah Campbell, you have it. And I want you to know when you leave here, you're the very first one. So get on pictures if you want. She has you have an illustrious career in front of you. She has an illustrious career in front of her. That's what's important because y'all always have that. So kind of revel in the moment a little bit. And best of luck in all you do.
You should have gone live.
I can go again.
Hi, I'm Brittany Faith. I'm also in Chattanooga, Tennessee. I'm an
court for a special immigrant juvenile visa, and my witness almost got their uncontested motion denied. So witnesses are amazingly important, and I was really blown away with witnesses. I'm not normally like whenever I judge my trial around like really super focused on the witnesses, but you guys did such a good job this year. I think because the cross and everything, the first direct was that word, was so smooth that it allowed everybody to shine, and I'm just so proud of all of you. And I echo everyone else's call to go to law school and enjoy the TBA and Young Lawyers.
Well, Ross is practice. It's my first time on the bench, and I couldn't have gotten off to a better start than by seeing all of you. So again, congratulations to all of you for all to be commended. I now have the pleasure and privilege of announcing the winner of this final round of the 2022 competition. And the winner, both in terms of scoring and the substantive verdict this evening, is the defense